Imagine you've hired a team of people to build a pool in your garden. You say you want to have a diving area that's 7 feet 6 inches deep, but as it turns out, they only built it to be 6 feet 9 inches deep. Pretty annoying, sure, but what can be done about it? Leave the building company a bad Google review? Don't hire them for future projects? Or try sue them? In the case of Ruxley and Forsyth, Mr. Forsyth, the defendant, initially went for the don't pay the builders option. The claimant construction company, Ruxley Electronics, tried to sue him to get the money owed to them as part of the building contract. Forsyth countersued, saying that Ruxley hadn't respected the depth requirements contained in the contract. As a result, Forsyth argued, Ruxley needed to hand over the cost of curing this contractual breach. It would have costed £21,500 to reconstruct the pool to make the diving area 7 feet 6 inches deep. Forsyth thus wanted to offset the money he owed to the builders by this amount of money, so that he would only have to pay in effect 2/3 of the overall sum. The issue was that it seemed disproportionate to effectively impose this huge cost onto the builders. The pool was still perfectly safe to swim and dive in, especially as Forsyth hadn't planned to put a diving board by the pool, nor had the value of Forsyth's property been reduced by the breach of the contract. Because of these considerations, the trial judge had instead opted to award Mr. Forsyth damages for the loss of amenity as a result of the breach, amounting to £2,500. The Court of Appeal reversed this and instead awarded the cost of cure of £21,500. But most importantly, what did the House of Lords have to say? It was ultimately held that the trial judge's award was the right one, meaning the Court of Appeal decision was reversed. The Lords' judgment held that there are 3 ways to measure the damages for breach of a building contract for defective performance. Firstly, the depreciation in value of the property, so here that would have been £0, the house price wasn't affected. Secondly, there's the cost of cure, so £21,500 to reconstruct the pool, or the loss of amenity caused by the breach to the consumer, £2,500, according to the trial judge, and also according to the House of Lords. So the measure of damages that is ultimately chosen by the judge would be that which is most reasonable, and that's what the House of Lords did here. A proportionality test would be applied as well, so where the cost of cure of the breach would be out of all proportion with the benefit that would have been obtained by the claimant had the contract been properly performed, amenity damages would be awarded instead of the cost of cure. So this sounds quite complicated, but basically it just means here that Forsyth wouldn't have received much benefit from the pool being reconstructed, and the cost of reconstruction would have been very high, making the cost disproportionately high compared to the benefit. Instead, the reasonable award of damages was the loss of amenity award. This is designed to compensate for the damage done to the claimant's enjoyment of the good or service in question, caused by the breach of contract. Because the pool wasn't as deep as he'd hoped it to be, he wouldn't have enjoyed it as much as he otherwise would have. So he was entitled to claim £2,500, not £21,500. Here the court also applied a rule from a previous case called Jarvis. There's a summary that we've done, which is in a link in the description. This rule states that while courts in general do not allow recovery for hurt feelings, such recovery is allowed where the object of the contract is to provide pleasure to the consumer. Please remember to subscribe to the channel to keep updated with case summaries and to check out our website. The link is in the description.